I want to bring in someone who has experience on both sides. David Henderson is a civil rights attorney. He is also a former prosecutor. Before we get to that, I do want to ask you really quickly. I just got this email from the Deputy Chief of Staff for the Attorney General here. And I'll just read part of it for our viewers, and then we can talk about what it means. Basically, the state fully ready to go to trial, according to the AG, but the trial must be conducted in accordance with the rules of the law. Now that Mr. Chauvin has stated his intention to appeal Friday's ruling to the Minnesota Supreme Court, as is his right, the district court does not have jurisdiction to conduct jury selection or hear and rule on other substantive matters in the trial. What does that mean?
Let's talk about this two different ways, Craig. Let's talk about it in terms of what the law literally says and what it means in terms of trial procedure, and those are two separate discussions. I cannot overstate the importance of that third-degree murder trial being part of Chauvin, that charge being part of this trial. But what this tells me more than anything else is that there's hesitation on the prosecution in terms of moving forward aggressively. And that matters because you're not likely to see a conviction if they are not aggressive in prosecuting Chauvin. I think that with this whole discussion, what's happened so far, the easiest way to think about it is like this. When the appellate court tells a trial court what to do, it's like a parent correcting their child's math homework. They'll tell you what you got wrong, but they're not going to fix it for you. They sent it back down to the lower court to fix it. I think they made it very clear on Friday what they expect to be fixed, and it makes me nervous that the prosecution's nervous about whether or not it can move forward in light of what the Court of Appeals said.
Okay, thank you for helping us understand that. Again, that just came down a few moments ago. You've represented several plaintiffs in police brutality cases. Can you talk about the unique challenge of jury selection in this particular case? Again, I mean, this is video that's been seen around the world. What specific things would you look for as a prosecutor when trying a case like this?
Absolutely. What I'm going to look for as a prosecutor more than anything else is the tone that this trial is beginning with. You're beginning with a trial judge who said that they don't want to follow what the Court of Appeals told them to do. And you're the one who's challenging him. What that means is that when you challenge a judge, other things tend not to go your way. In addition to that, moving into jury selection, the manner in which jury selection is going to proceed in this case strongly favors the defense. And I have to say in no uncertain terms, if Chauvin's lawyers are good at picking this jury, they could very well end up with an all-white jury. It's not that difficult in light of the questionnaire that was presented. It's easier to disqualify people who are in favor of Black Lives Matter than Blue Lives Matter. The only shot you have as a prosecutor is trying to rehabilitate people that the defense is going to want to strike. And what I mean by that is sometimes a jury says, you know what, I'm too biased to serve on this case and be fair and impartial. You've got to get people who say that, who are biased in your favor, to reverse themselves. It's the only way you've got a shot of winning this trial, if you're the state.
You mentioned the jury questionnaire, but I mean, prospective jurors in this particular case, they filled out a 16-page questionnaire with very specific questions, David. Questions like whether they've attended protests against police brutality. Did they carry a sign at a protest? If they did, what did the sign say? What are defense lawyers what are lawyers for Chauvin looking for? How do they strategize around them?
So Chauvin's lawyers are going to have a field day with this jury selection process. And something I should have said toward the beginning is that I've tried civil rights cases, but I've also tried capital murder cases here in Texas. And the way that they're picking this jury is the way you pick the jury in a capital murder case. That's the only time you bring jurors in one-on-one. And typically when you're picking a jury, you get 5 minutes or less to talk to each individual person. Here you're going to have substantially more time. Not only are the questions specific, Craig, but they're loaded questions. For example, there are questions about, on a scale of 1 to 5, how do you feel about, quote, defunding the Minneapolis Police Department? There's questions that say on a scale of 1 to 5, how do you respond to the statement, I don't trust the police? It's hard to imagine a world where someone identifies with those statements and then is not stricken what we call for cause. That's when they basically establish, I can't be fair and impartial. Then even once you get past that point, the defense has 15 strikes, which again is how many strikes you have in a capital murder trial. I have never tried a case where one side wasn't trying to strike African Americans specifically, unless there just weren't any on the panel. And with the demographics of the county in which this jury is being picked, and the number of strikes that Chauvin's lawyers have, because they've got more than the state, that's absolutely a huge advantage for them in picking this jury.
David Henderson, thank you for your insight. Thank you for your perspective and analysis there, sir. We'll be calling on you over the next few weeks and months. Thank you.
Thank you.
Thank you.
Thank you very much.
Thank all of you out there.
Thank you as always.
Thanks to at home.
Thanks for watching. Thank you so much for letting us into your homes during these extraordinary times.